Our next presentation is The Landscape Revisited. And I'd like to say a few words of my own on my opinion on the land decision. The land decision, in my opinion, gave foster children a fundamental civil right that they had been denied previously. Privacy in therapy is something that creates an atmosphere of safety. What happens in therapy stays in therapy. Without that sense of safety and privacy, therapy is completely ineffective. Foster youth are perceptive and smart. When we know what we say is going to be used against us, we keep our mouths shut. When I was in care, I never used therapy as a tool for healing myself. I went through 5 therapists in the short time that I spent in care, and I only shared my story with one therapist who was seeing me temporarily as I was between therapists, and she was just an intern. And for some reason that felt safer than the other therapists who I knew were reporting everything that I said back to the GALs and social workers. Even then, I was still very conscious of what I was sharing. I made sure that the things I shared were things from the past, things that couldn't be used against me. My sister was put in a mental institution after she shared some of her inner turmoil with her therapist. And that was when I realized foster children aren't given all the same considerations, all the same civil liberties as other children, like privacy and therapy. The LAN decision gives foster kids that right, and with that right, my hope is that more kids will use therapy effectively without fear of retribution, and hopefully therapy can help them heal so that they leave foster care a little less broken than they entered it. When the decision was made and we discussed LAN at the OCR board meeting, I was filled with a sense of pride and progress. Good things were happening for foster kids. The Supreme Court was supporting us. I heard doors crashing open, opportunities to right other wrongs. And then I heard the frustration from the attorneys on the board. This decision makes their jobs harder. And I understand that frustration. An extremely, extremely difficult job just got a little bit harder. However, I think in order to understand someone, anyone, you must first walk 2 moons in their moccasins. And even though everyone in this room intimately knows children in foster care and understands where they come from, I still think that the foster care shoes can be a little bit difficult to squeeze on. So I think that the LA decision can be translated loosely into divorce proceedings to kind of understand and put yourself in the shoes of the foster kids and try to understand how important therapy and privacy in therapy can be. We all understand divorce. It happens a lot in our society, and it's very similar to foster care. You go to court and your livelihood is decided for you. It's largely out of your hands. Every little part of your life is discussed, and someone decides what's going to happen. It's out of your hands. So I think if we all think of it like that, would you go into therapy if you were getting divorced and share secrets and share your personal opinions if you knew that those secrets and opinions were going to be read again in court and could be used against you? I don't think you would. And I think if we consider that foster children have been traumatized and have been through difficult life experiences, and therapy, there's a reason that foster children need to go to therapy. They need to heal. And without privacy and therapy, foster children are too afraid to share if they know that what they share could potentially be used against them. And so I think that the most important thing to consider while we discuss the landscape is not how much harder does this make my job. I think what's really important is how much more does this help these kids. If this makes my caseload a little heavier, but how much lighter will it make their life if they're able to effectively use therapy to heal? Our next presenters are the Honorable Charles Greenacre, a district court judge from the 7th District, Laura Dunbar, a GAL who currently works in Adams County, Bob Tweedle, an attorney who is very active in Delta Family Treatment Court, and Ann Parmley, a longtime GAL who also works as an RPC in the 5th JD. and they will be discussing the implications of the LAN decision in dependency and neglect proceedings.
We're going to start today with a brief review of the facts of LAN. I know that some of you know those quite well. I think Amy is probably here, but we thought a brief refresher would be good to just to remind ourselves of the facts of the case as the Supreme Court recited the facts. LAN had remained with her aunt after the child was adjudicated in March of 2009. The aunt hired a licensed professional counselor to provide therapy for LAN beginning that same month. And LAN continued in therapy after moving into her grandparents' home later that year. February of 2010, the therapist wrote a letter to the GAL assessing LAN's progress. The letter contained a number of the therapist's specific observations from her therapy sessions with LAN. For example, the therapist expressed concern about the parent's level of anger that I have heard about from LAN and witnessed myself in the courtroom after court hearings. She additionally quoted LAN, the therapist quoted LAN directly several times, including statements such as, "Mommy hurts bodies," and "I'm fine with visits at Mommy's house as long as I don't have to go alone." So those, then the GAL distributed the therapist's letter to the court and to all the parties without mentioning the privilege one way or the other. Department filed a motion for termination of parental rights. Mother's counsel subpoenaed the therapist to appear for a deposition and produce her entire case file. The therapist's counsel moved to quash the subpoena and asserted the privilege. Hearing was held. The court granted the motion to quash as to the records and case file, but not as to the deposition. The court held neither LAN nor the mother could waive the child's privilege. The court held that it had authority to authorize a limited waiver of LAN's privilege because, the court reasoned, the court had allowed and encouraged the therapist to report to the court regarding LAN's therapy. The court balanced the risk of disclosing the therapist's records and thereby damaging the therapeutic relationship between LAN and the therapist against the mother's interest in putting on a sufficient case to protect her rights. The court held the mother's counsel could depose the therapist, but that the therapist should not disclose her notes, videotapes, personal records, because doing so was beyond the scope of any limited waiver of LAN's privilege. And then mother's counsel did proceed to take the deposition, and the therapist did testify at the termination of parental rights trial. And those are the basic facts. Go.
Well, this is a panel discussion, so if you have any questions as we go along,
thank you.
raise your hand and we'll try to answer them. Also, I apologize, I don't have any fancy PowerPoint presentation. I do have an outline with some case citations, and I will email that to Ashley so that it can be available if you're interested in those cases. I'm, of course, a trial court judge, and I do the entire docket in Delta with the exception of the domestic docket. So I have a chance to see various types of cases, and it's my experience that the issue of privilege prior to LAN arose mostly in the civil arena. And the attorneys in civil law and civil cases are very well aware of the disclosure requirements and the process for making privilege claims through the use of privilege logs during the disclosure and discovery process. However, I think for those of us that do neglect and dependency cases, that where the general rules of discovery and disclosure normally don't apply, that these procedures and the case law to some extent is unfamiliar. So what I would like to do is go through a review, somewhat of a review of the law of privilege as it's developed primarily in civil cases, because I think the Land decision relies on that law, and I think you're going to see it being interpreted as we go forward as an extension of the general law of privilege. As you probably know, the burden is on a party asserting the privilege to prove that the privilege applies. And the party who is asserting a waiver of the privilege or any privilege also bears the burden of overcoming the privilege. A privilege holder can waive a privilege by words or conduct that indicate an intent to forego the protection of the privilege. Now this, of course, can be done formally by signing a release, but it can also be done informally. The waiver can be either express or implied. And I would like to go through some of the cases that have found implied waivers, because I think that's essentially the basis of the Land decision and what we're going to be dealing with in the future. The first case is Clark versus District Court, and that was a civil case, and the court held in Clark that a privilege holder impliedly waives the privilege by injecting his or her physical or mental condition into the case as the basis of a claim or defense. Now, the most common situation is the person that's involved in an auto accident and has a physical injury. They are claiming damages for that physical injury. The courts have held that that's an implied waiver, and any medical records that you have or treatment that you receive for that physical injury is subject to disclosure and discovery under the civil rules. But a party in a lawsuit can also waive the privilege by just giving testimony at the trial regarding the nature, extent, and cost of the medical treatment that they received. In that case is Morrow versus Tracy. That actually goes back to 1963. So you can see that there's a long history of implied waivers in our law. The next case that I find interesting is Kelly versus Holmes. This is a 1970 Colorado appellate case. In this case, the plaintiff called 2 treating physicians to testify in his case in chief regarding the treatment that he received. Well, the defense wanted to call the 3rd physician, treating physician, and the plaintiff said, "Oh, I object, Judge, I have privileges to that testimony." The court says, "No, you've waived that privilege because you have called 2 physicians who treated you for that particular condition, so the defense can call the physician, your 3rd treating physician, even though you wish to assert the privilege and think that testimony might not be helpful to you." Now, those cases, Clark, Morrow, and Kelly, are cases in which a party had control over the implied waiver of the privilege. But there have been some criminal cases in which the issue has been raised in regard to witness testimony. And in People versus Cisneros, which is a criminal case, 2002, the court held that a victim or witness in a criminal case may waive a privilege at trial by testifying regarding their post-assault, by testifying regarding their treatment sessions and thereby putting their post-assault mental health in issue. So in those circumstances where a witness raises those issues, the parties to the case may be able to argue that there was an implied waiver because the witness made those disclosures. Now, all of those cases are trial cases. There's a case, Burlington Northern Railroad Company versus Hood, in which the privilege was held to be waived by a party who did not assert the privilege at a deposition. So there was testimony at the deposition regarding medical treatment. There was no objection to that deposition testimony, and the court held that that constituted a waiver of the privilege. and that information could be available through discovery and disclosed at trial. The final case I'd like to bring to your attention is Denver Post Corporation versus University of Colorado. This involved the attorney-client privilege. And the University of Colorado was doing an investigation, an internal investigation regarding whether some professors had received improper payments regarding a medical facility that was being built, I believe, in Saudi Arabia. And they used their attorneys to do this investigation. And the attorneys developed a work product that they, as a result of contacting and communicating with employees of the university, to whom the attorney-client privilege would apply. But the university then turned this information over to the Denver District Attorney's Office. And the Denver District Attorney's Office had prosecutorial authority and could have brought criminal charges against either the university or the employees. Denver Post wanted to get this information. The university asserted the attorney-client privilege, and the court held that that was waived because the university had turned the information over to a potential adversary. So you can see that there's a number of situations in which there can be an implied waiver of the privilege. And this, I might point out, is a non-exclusive list. There's more cases certainly, and there may be other situations in which there may be an implied waiver, which is, I think, an important issue under Land, because Land did not discuss all the ways in which the privilege may be waived. Now, there's very little law, either in Colorado or in other jurisdictions, on limited waivers. And there's only one case that I've been able to find in Colorado. It's called Devenys, D-E-V-E-N-Y-S versus Hardy. And in that case, the plaintiff was injured in an auto accident and brought suit against the defendant, who was the driver of the other vehicle. The defendant was covered by what we used to call PIP coverage, which we no longer have in Colorado, personal injury protection. And it was first-party coverage that you had under your insurance policy, your auto insurance policy, that paid a certain percentage of your medical bills up to certain limits. And the defendant driver had submitted bills to and information to its insurance carrier, its PIP insurance carrier, to receive benefits. The plaintiff argued that that was a waiver of the privilege because of the disclosure to the insurance carrier. And the court held that that did not constitute a waiver, that the waiver was limited only to the insurance company. Because the defendant driver had to submit that information to the insurance company in order to receive payment. That's the only case I'm aware of in Colorado, and frankly, there's not many other cases in other jurisdictions that discuss limited waivers. I think the question that we're going to be dealing with going forward, to the extent that we are dealing with waivers, especially express waivers, is can they be limited, and if so, how and to what extent? Now, the waiver in Land, the court in Land held that the GAL had impliedly waived the child's psychotherapist patient privilege by disseminating this therapist's letter when there was no need to do so. The letter was 5 pages, single-spaced. There was a lot of detail and material in the letter. So the court held that that was a waiver. The waiver, however, that the Land court did not address, and I think is the more important issue going forward, is whether or not the privilege is waived if the therapist testifies at any hearing. And this would be under case law, I believe, a case where, a situation where there is a waiver of the privilege if the therapist testifies either at the instance of the privilege holder, or if the therapist is called by another party and the privilege holder does not object to the testimony. And I think that's going to be the more difficult issue that we have going forward. And I can see this arising in cases where we either have, most likely post-adjudicatory, where we either have a placement hearing or a termination trial, and the child has been in therapy for some period of time. Now,
The last thing I want to talk about is privilege logs, because as a trial judge, I can tell you this is an issue near and dear to my heart. Lots of times I'll get documents in chambers and I'm supposed to look at them, and I've looked at social services records and they're 5 volumes, and it's like looking at a needle in a haystack. You don't know what you're looking for and don't know what's relevant and so on and so forth. But the land addressed the issue of a privilege log if the court has to make a determination as to whether or not the privilege applies. And the privilege log is defined in the Colorado Rules of Civil Procedure, Rule 26B5, and it provides that when a party withholds information required to be disclosed or provided in discovery by claiming that it is privileged, the party shall make the claim expressly and shall describe the nature of the documents, communications, or things not produced or disclosed in a manner that, without revealing information itself privileged or protected, will enable other parties to assess the applicability of the privilege or protection. Now, as I've indicated, privilege logs are used extensively in civil actions to assert privileges during the disclosure process, very early in the case, to assert the privileges as to documents that have to be mandatorily disclosed.
The court in Land cited Alcon versus Spicer. In Alcon versus Spicer, the court made the following statement regarding the privilege log. In the privilege log, the party asserting the privilege must list the records claimed as privileged, document by document, with a description so that the parties in the court can determine the applicability of the privilege. Now, I think the concern here is that if we're going to try to resolve the privilege based upon the privilege log alone, without the court having to review the documents in camera, there's going to have to be enough information in the privilege log so the court can evaluate, and the parties, because the parties, of course, can make arguments regarding what's privileged and not privileged, can make argument, and the court can decide on the basis of the privilege log whether the documents are or are not privileged. And it may be that a simple description will do, the therapist notes from meetings with the child. But there may be documents that aren't privileged. The privilege rests upon a statement or communication made by the person receiving treatment to the therapist. And of course, the case law holds that any notes or reports of those statements or any treatment records are also covered by the privilege. But the therapist may have information from other sources that impact their opinion. And unless the court knows the source of that information and can make the link between the information and the source of the information, may not be able to make a determination as to the privilege applying based upon the privilege law. There is some case law, once again in the civil area, that says that if an expert testifies that the other parties are entitled to have any documents that that expert relies upon. In the specific case was a medical malpractice case, and the attorney retaining the expert had written a letter to the expert, and the court held that that was discoverable because the expert had relied upon it. But I think there's also situations in which the expert may get information from third persons that is not privileged, and it is subject to disclosure. So if, as we move forward, I think the courts will find it very helpful if you can be as detailed as possible in your privilege logs. Are there any questions at this point? Yes, sir?
Is it okay if I press you about
Can you wait till Melanie?
We were asked to wait for the microphone.
Thank you.
No, it's loud enough without the microphone. Okay, is it okay if I press you about limited release of...
Sure, as much as I know.
Well, and I understand that. The situation came up that the court is ongoing in good argument by the defense counsel in that particular case, where, and I think it's going to happen more and more, and that is the therapist released information to the department, all right, about the child that was probably privileged. And the guardian ad litem exposed it, and then the court asked the court to limit it to that release, or to even to keep that record from going up to anybody else. So limiting the release only to the department. Now, obviously, as we go on, I'm one, going to want to see the document so I can determine as to whether it is the core of the therapist's opinion. Two, I'm going to point out that the other party now has information that I don't have, and so that the due process violation is just a strategy. And then three, maybe in the future, if there's a contested hearing, we'll call the therapist. And I'm going to want to see all of her records because the door is open. What is the guardian ad litem supposed to say under those circumstances, as implied in Land, that he may be able to do in order to be able to prevent this from being more of a problem?
Well, I'm concerned about the issue of limiting a release prospectively. Because this inquiry and the inquiry the court's supposed to make under Land is very fact specific. So at some point in the case, early in the case, for example, I'm assuming the guardian ad litem holds the privilege, a document may be released with the consent of the guardian ad litem to one or more of the parties, and there may be an effort to limit the use of that release. And I think it's very difficult to say that either the parties or the court can limit that use for any and all purposes that may arise in the future. That, I think, is an issue that's going to have to be litigated. Okay. Any other questions?
Here's one. Thank you.
If I can kind of deal with a related issue. As a GAL, I am not the guardian of the person or the custodian. And the person who is the department. And the department routinely asks for therapeutic information in order to decide if they're even going to pay this person, if they're going to switch to a different therapist, if they're going to send the bill to Medicaid, if it's a Medicaid provider, it still goes. There's a lot of information that goes out. And as a GAL, my inclination is to say, no, don't give out any information whatever, because it might be a waiver. And yet, at the same time, if I do that, I know that that means that the department, as the appropriate custodian, is not able to accurately make assessments about, do we have a trauma-based therapy? Do we have a non-trauma-based therapy? Is this the appropriate therapy? And obviously, they need to do that. What does the court think about that? Well, in this case, the judge, I guess I should say the court. And what do you also think about the possibility of making agreements prospectively, that if you're in court and you're putting together a treatment plan, for example, that the treatment plan can have as a provision, okay, a certain amount of information is going to be released about therapy, but that will not constitute a waiver. And if everybody agrees that it won't constitute a waiver, does it actually, is that something that could be effective, or would it turn out that, hey, mom now has a different counsel and he says no?
Well, I think our remaining panelists are going to discuss.
I think that's a great question, because we heard information this morning about getting children into the right kind of therapy. And it's not always possible to know that at the beginning of a case. And what if we go down the road 3 months and really somebody thinks the child is with the wrong therapist? Well, how is anybody going to know that unless they've been provided information from the current therapist about what's going on? How would a caseworker or GAL or anybody else make that assessment about moving a kid to a different kind of therapy without getting some of the substance of the therapy that he or she is in now? I think that's a real problem.
And here's my perspective. Most departments are paying for therapy for the children, and most departments are requiring that the therapist provide them with information Perhaps not complete reports, but at least enough information to justify payment of the therapy, for the therapy. My concern, or at least my inquiry after land, is does the privilege holder, whether that's the GAL or a third party, need to consent to that release, and I think they do. And then I think the next step is we're going to have to determine the extent of that release.
I have a question, Judge. Do you think ever that the mere filing of a DNN case means that the child's mental or physical condition or the parents has been injected into the case? Okay.
No.
Okay.
It's not. It's my opinion that the physical or mental condition of the child, or the parents for that matter, is not injected into the case merely by the filing of the DNN. But I think it is injected into the case if it's raised by a party. And I certainly think it's injected into a case if somebody calls a therapist, either for a respondent parent or for a child.
And if somebody calls the child's therapist to testify at presumably a contested hearing, maybe placement or permanency or termination of parental rights, can that be limited in any way? If the therapist testifies, is that a 100% blanket waiver? I think so.
I always hate to give opinions before I am faced with the facts. One of the things that Land points out is, in Justice Rice's opinion, is the due process issue. And while they don't address it, there is, of course, a right, certain constitutional rights that parents have to their children, which is recognized by the higher standard of higher burden of proof in termination hearings. I think it's my view that going forward, that if a therapist is called and gives testimony that's adverse to the parents or to their parental rights, that's going to be viewed as a broad waiver of the privilege, and that there are going to be due process implications to having access to therapist notes and other information regarding their testimony. But see, I think that once again that's a situation in which somebody has placed that matter an issue. And so, for example, let's assume the guardian ad litem holds the privilege. If somebody else wants to call the therapist, I think it's the duty of the guardian ad litem to object to that, so that that privilege is preserved.
Okay, well, we need to move on. Can you wait, Kip?
I'm used to that.
Okay, sorry.
So my role on the panel is to talk about my personal experiences with land and also the approach that I've developed on how to handle the land issues. So my personal experience, when I first got the email from OCR, I went into panic. Panic mode was the first mode. Then I went into the mode of saying, wow, this is an overwhelming responsibility that I'm now going to have to take. And then my third reaction was, I better do something about this and do something fast. So I don't know if anybody else had those similar thoughts and experiences. And it hit me in the face right away because that evening that I got the email, I was reading over a case for review hearing the next morning, and the CASA report was reporting all kinds of information about the child's therapy, what was going on, the progress being made, statements being made, the issues being worked on, and I was like, oh, here it is right away. So the next morning I went into court and I asked the CASA to not report this kind of information. I asked the judge to strike that information from the CASA's report and that we would not be discussing it in court. And I cited the land case and the judge just looked at me. And I said, yes, there was a new case announced like yesterday, Judge, and this is what it's all about. And the judge looked at me and said, file a motion so that I can understand what the case is saying and where you're coming from with this. So that's what I did. So that's how things started for me. So the next thing that I really felt like I had to do was figure out what is this psychotherapist patient privilege. So I read, of course, the statute, which is 1390-107-1G. And what it says is it precludes examination of mental health professionals about any knowledge gained in the course of therapy without the patient's consent. That's pretty broad, any knowledge. There's case law that says the things that are privileged information are communications from the patient to the therapist, communications or advice from the therapist to the patient, observations of the therapist, and of course treatment records. So all of those things are privileged information. And then what does the privilege prohibit? It prohibits testimonial disclosure of that privileged information or pre-trial discovery of any of that information. So the next thing that I wanted to figure out is how important is this psychotherapist patient privilege that now I may have a role in trying to protect or having to protect. And so I think the young lady that introduced us, and I'm sorry I don't know her name, the panel today said it better than I could say it, but why is it so important? It's so important so that there is a safe place for these children and these adolescents that are now in the system to be able to develop trust. As Ms. Garanzo was saying in her presentation today, some of the symptoms that we see, some of the results of the trauma and the abuse and the neglect that have gone on are things like a lack of trust and having such a poor self-image and having attachment issues and just feeling betrayed and hopeless in general. And so we need to be able to protect vehemently the privacy of what's going on in therapy for these children and adolescents so that they can develop trust, number one, in their therapist, or else they're never going to be able to get healing if they can't develop that initial trust. And then give them that safe place where everybody's not trying to intrude upon what's going on in there. What issues are they working on? What's the child saying about this? There has to be that safe place for them. And I think that's first and foremost out of anything that we need to consider as GALs. So the approach that has to be used, first, file a motion, of course. That's the first step. Who is going to be the privilege holder and get a court determination about that? So as a GAL, I need to go through a process first before I can file that motion about who do I think is the privilege holder and who am I going to assert is the privilege holder. So I developed kind of a tier approach to that, how I go about that. So I think first and foremost, you have to consider that the child holds the privilege. Does the child hold the privilege? Because after all, this is a personal privacy right of the child, and it's personal to them, this privilege. So is the child in a position to hold their own privilege, be the holder of their own privilege is the number one. I think most GALs and most courts have started using that bright line rule of 15 because that's the age of which you can consent to mental health treatment. I don't know necessarily that we have to say 15, but I think that's the practice that's going on. I think there's going to be other situations that perhaps a child younger than that could be their own privilege holder if they're mature enough and they have well-reasoned thoughts about their therapy and the release of information or sharing information, that it could be a child younger than that. And there's certainly nothing in land that precludes a child of any age, really, being the holder of their own privilege. So I think that's the first place to start. If you decide as the GAL shouldn't be the child in this situation, I think the next place you have to look is the parent. The case law, Lindsay versus People, says that the parent is the natural person to hold the privilege for a minor child. So then the next step is, should the parent be the one holding the privilege in this case? Land is very clear about when parents should not hold the privilege. And what Land says is that if the parent is in a position where they have the incentive to strategically assert or waive the child's privilege, that could contravene the child's best interests. And that's a place where the parent should then not be the holder of the privilege. So I think you have to look at, so is the parent in that position or is the parent not? I think of like the Troxel line of cases right away, which is presuming that parents, fit parents, are making decisions in the best interest of their children. And in our cases, we don't really have a determination at the beginning of cases that parents are not fit. Certainly they have problems and issues, or they wouldn't be in the dependency and neglect court in the first place, but they're not unfit per se at the beginning of cases. So they are in a position where they could make decisions in the best interest of their children. And certainly in the cases where we're leaving the children home with the parents and we haven't decided that the situation is bad enough to remove them, the parents are probably in that position still to make decisions for the best interest of their children about what to waive or what to assert as far as the privilege, the psychotherapist patient privilege. But I also think that parents are in a bind that we have to think about too. They have treatment plans that require them to sign all kinds of releases for their own treatment and all the services that they're involved in. I don't think, and maybe I'm wrong, and I was just thinking about this as the judge was talking, that they're required to sign, as part of their treatment plans, releases about their child's therapy. I'd like to look at that though now and make sure that's the case. But I don't think they're required to. But I think parents feel like they are required to, because they certainly want to come across as compliant with social services, working on their treatment plans, cooperating as best as possible. And I think they feel like they have to sign these releases up front, rather than really doing a decision-making process about, should I release things about my child's therapy or shouldn't I? So I think if the GAL decides the parent is still in a position to hold the child's privilege, then I think we still have to be conscientious about watching that, to see what decisions the parent is making. And if they really aren't making decisions about waiving that privilege or asserting that privilege that's in the child's best interest, maybe that's the point then when we have to file another motion and ask the court to redetermine who the privilege holder is. So that's my thing for parents. And what I have done around parents so far is I have filed motions saying I think that the parent should be the privilege holder. And then in other cases I've decided there probably shouldn't be the privilege holder at this point in the case. Obviously, land came around when we were all in the middle of a lot of cases. So for me, if I am in the position of having a contested issue in a case, like a placement hearing or trying to suspend visits of the parents, or there's a contested issue about expanding visits of the parents, or returning the child home, or certainly a termination hearing, I think that does put the parents in a position where they're going to strategically waive or assert the privilege that is not necessarily in the child's best interest. And at those postures in the case, I'm asserting that it's not the parent who should hold the privilege. Other situations when I've done that and said it should not be the parent is, I had a case that did not start about sexual abuse issues. It started over other issues. The children were in therapy and they started disclosing sexual abuse by both their parents. So I filed a motion and I said, Judge, I think at this point, because the parents they're in a position where they could strategically assert the privilege to keep this information away from others from being disclosed. Now, of course, if the therapist gets direct information, they would disclose that because it's a child abuse report. But there's other information around that might not necessarily be disclosed, that continues from the children after that. That may not be a direct child abuse report, but it relates to it in some way. So I filed a motion then saying I think the parent is now in a position that they're not going to act in the child's best interest, and it should be no longer be the parent that's the privilege holder. And then I had another case where I just did the same thing, and this was a case of parents who had adopted a kid young with fetal alcohol syndrome. When he became a teenager, they decided he was too much to handle, and they wanted nothing to do with their child. He got placed in residential care, and they were basically saying, we're done with the child, we want nothing to do with our child, we don't even want a relationship with our child anymore, but of course we're not going to let them relinquish their rights. So at this point I said, I think these parents are not in a position to make decisions for the best interest of their child because they really want nothing to do with their child. So I think it's a case-by-case analysis is, I guess, the point I have to make. And there's no bright line. I don't think you can say just because the child's in foster care, the parents shouldn't have the privilege, or just because the child's at home or whatever. I don't think there's a bright line. So I think it's a real analysis. Then my third tier in this analysis is I think others should maybe hold this privilege before the GAL, like kin or relatives who are providing care for these children, who are taking care of them on a day-to-day basis, who take the child to therapy, are involved in the therapy, know what's going on there, know what the behaviors of the child are. Perhaps they are in a better position to be the holders of the privilege. And in land, there's a footnote 2, that basically says the court's making their decision in land that the GAL is the privilege holder just because only 3 choices were given to us. The department, the parent, or the GAL. Nobody presented kin. Oh, I'm sorry, the child. Nobody presented kin or relatives. So I don't think there's anything that precludes kin or relatives from being the privilege holder, and perhaps they're in a better position to be the holder of the privilege. So for me, the fallback position is it's the GAL. And maybe others approach that differently. And I just want to say, this is my approach. I'm not saying this is the best approach. I'm sure other people have much better approaches than I do. But I'm hoping that my approach gives people food for thought about how to handle this situation. So to me, the GAL is the fallback position. That if nobody else seems like they're in the better position to do it, it should be the GAL. And I think when the GAL takes on that role, it is a pretty overwhelming responsibility that we have to take so very seriously. And it's a difficult situation to weigh, releasing information, is that in the best interest of the child or not? Just the question that just came up and the answers in Ms. Garanzo's information this morning, I didn't think about that until she was presenting it, we do have a responsibility as the GAL to know what is going on in that therapy. And of course, if we're the privilege holder, we're going to know that. But we have a responsibility, or somebody has the responsibility, to find out, is the therapy working? Is it still beneficial to the child? Is it the correct modality of treatment? Is progress being made? Are there other interventions that should be going on? And who is in the best position to do that? Sometimes I don't feel like that's me. I don't have all the training that's being presented to the caseworkers and so on and so forth about matching symptoms with treatment modalities. I have some training, but I don't have a lot of training behind that. So maybe I'm not the person who's in the best position to be getting this information and making those decisions. And so perhaps we do have to think about, do we want to waive the privilege and give the caseworkers more information around those issues? But I also am very wary about whether or not we can construct limited waivers of the privilege. And so I think as the GAL, when I'm the holder of the privilege, I really sit and think a lot about this. If I'm in the position where I'm going to waive the privilege and give out information, I think I have to expect that it's not going to be a limited waiver, and that I'm now opening the door to everything being disclosed. And I have to know what everything is first and foremost, and then I have to decide which is better. So I think it's an awesome responsibility, one that we really have to make sure that we really think a lot about before we do. And in situations where I've disclosed information and considered it and decided I should disclose, is when those contested issues are coming up, and the therapist's recommendation is key to the judge making a determination one way or another about visits or placement or return home or even termination, that we have to know much more about the children's conditions and needs emotionally, and their mental health conditions and needs, to be successful at the termination. I think a lot of times in the past, people have put the therapists on the stands when it's not absolutely necessary, and there are other sources of information that we could go to besides the therapist. So I think we have to think about that too. But if it is absolutely necessary to hear from the therapist on these contested kinds of issues, I'm going to waive the privilege if I'm the privilege holder, because I think it is in the child's best interest for some of these very key decisions to be made, and to be made in their best interest. So I am going to waive the privilege in those situations. But I think it's hard, because I do come from the standpoint right away that I'm going to protect the information. I'm not going to let social services have the information unless it's absolutely necessary. And I don't think things like attendance at treatment is the confidential nature of the underlying privileged information. I think attendance is probably something that's not covered by the privilege. I could be wrong about that, but that's what I think. But when you get into nitty-gritties about progress and those kinds of things, I think that's a pretty dangerous territory, and you better really think about whether it's the right thing to do, weighing the dangers and the benefits before allowing social services to get that information. So one of the first steps I also do in the case, besides file my motions, and in my motions, just so you know, they're out there in the electronic material, I ask for a prohibition from the court that nobody contact the therapist yet and get information until the court determines who the privilege holder is, and then there's a release by the privilege holder. And I also ask for a very limited waiver ruling by the judge to allow the therapist to share information with the caregiver of the child, because the therapist needs to be able to give advice to the caregivers if there's some fears that come up in therapy that need to be addressed in the home, or parenting issues that need to be addressed immediately. So I asked the court for a limited waiver to allow the therapist to share advice with the caregiver about how to handle certain situations parenting-wise. I've not had any challenges about that, and people have agreed to that yet, and it hasn't been a problem so far, so we'll see what happens. And the other thing I just want to say that I do at the beginning of the case is I call the therapist. When I find out that their child's in therapy, and I say, I want you to know that I'm filing a motion for the court to determine who's the privilege holder. So right now you're operating without knowing that, and I think you should be aware of that situation. So if you are sharing information with anybody, you need to know right now there is no designated person to allow you to have that information. And so I think you're in dangerous territory. Maybe you could talk to your attorneys about it or whatever. And when I find out who the privilege holder is, I will call you and let you know, so then you can operate the way you think you should in that situation. So I give those calls right up front, and I let them know that's the situation. I'm trying to control whatever sharing has already been going on, if they're sharing with the department or whatever, right away, because I think that's important to do. So real fast, I just want to say, what could I be doing better? I could be doing a lot of things better, but I can tell you that one of the things I could be doing better is I have not really filed motions I file motions at the beginning when I know the children are in therapy, but I haven't kept up on, am I at a position now where I think I should change, there should be a change in the privilege holder and I should file another motion. So I need to keep up on that and file more motions in that regard. I think I also need to request more often that relatives or kin are the privilege holders. And I think I need to actually examine the therapy files. So far I've been relying on talking to the therapists a lot, finding out from them what they say the information is, but I haven't physically gone down in there and examined their files. So I feel like I could be doing better in that area, and that's what I need to do. So those are my thoughts right now. I haven't had a contested hearing yet. I've been able to work them all out, the situations. So I haven't had that experience yet. I haven't had requests from respondent parents to get the therapist file, which I was expecting, but I have not had that situation. So there's a lot more to learn, and hopefully we can all do it together.
So one thing I was hearing, Laura, is you think during the course of a DNN case that the privilege holder could change from one person to another. Do you think that'll be common or rare?
Common.
Okay. And it could be one person for one kid and a different person for a different kid in the case?
I suppose that's true, depending on who's the subject child of contested issues.
Well, it sounds very complicated. I wish you could give me
Hopefully
a simpler
I shed some
answer.
light on it. I don't know.
Okay, well, I'm going to talk just a little bit about...
Can we save the questions till the end, or is that okay?
Okay, well, we're going to try to watch the clock here. I'm going to talk briefly about some of the questions that the LAN decision did not answer, and I'm going to go very quickly to leave Ann some time. I'm sure all of you have already thought of some of these and could probably think of a lot more, and I'll just mention a few due to the time constraints. I think one of the big ones is, what are CASA volunteers entitled to? And I'm imagining that many of you have thought about that, and there's jurisdictions around the state struggling with that, and people working on revising the court order appointing the CASA volunteer. So the tension is between the privilege statute and the CASA statutes, which talk in very general, pretty broad terms about CASA volunteers are entitled to lots of information. So what should the court order say? And legally speaking, how are trial courts going to rule in terms of what they're entitled to? I don't think we know. So I think that's a big one. Another one that we've already touched on is, and we've touched on several of these, could the court appoint somebody else besides the child, the parents, or the GAL? What if you have a child who's been living with his grandma for 5 years, and maybe the parents are really not involved or only very little involved in the child's life? Might not grandma be the appropriate person to be the privilege holder? Can a court appoint grandma? LAN really did not address that. Another one that we've touched on already is, what if you have court reports coming into the court attached to motions or, well, typically a motion filed by the department, and it contains information about the child's progress in therapy. Maybe it's fairly detailed, maybe it's not that detailed. That means the caseworker's been getting information. So I think some parents' counsel could reasonably argue that that's some kind of a waiver because it's coming into the courtroom, everybody else is seeing it. So that's something to watch for is what's going to be going into the court reports, and might that constitute a waiver. Another one on the limited waiver issue that's been discussed already quite a bit is what if the GAL holds the privilege and attempts to execute a limited waiver and spells it out in great detail in the written release. Well, I agree to let X, Y, and Z have information, but not A, B, and C. Can you do that? And that gets back to some of the due process arguments about can you limit it to one party but not another? And I think that will have to be litigated. Let's see, Judge. Those were kind of the main ones. We have some more, but I do want to try to move on. So Ann, go ahead.
Sure. My role on this panel is as RPC, and I, of course, do GAL work as well. So when this case came out, I had to, put on two different sets of glasses, I guess, and look at it from two different perspectives. And today I'm going to address my perspective as RPC, and which isn't that necessarily that different. I think a lot of things that have already been said are consistent to how, as RPC, we look at it. The land case, although it changed how the holder of the privilege might be if it's not the parents, I think it's still, firmly noted that the parent is the proper person to hold the privilege if the child is not holding the privilege. And I certainly agree. I think we all have the obligation first to look and see if it's appropriate for the child to hold the privilege, whether or not we're parents' counsel or GAL or in any role in this case. And so that's kind of a separate piece. And while as RPC counsel, there may be time where our parent, would prefer to have the privilege over the child, that's also can get into sticky waters in terms of reunification. And certainly from the RPC perspective, as is everyone's, the first and foremost thing is to try to do everything in the best way possible for reunification to be successful. And so as I look at it from that perspective, as when a parent, whether they recognize their mistakes or don't, or recognize the need for court intervention or don't, either way, as they walk through this process, and when I advise clients, especially through the adjudication piece, I kind of describe it as walking through a door into a new room where the rules are a little bit different than they were before they walked through that door. And they kind of walk in with I kind of think of it as a bag of parenting rights and tools and pieces that make up their role and their authority as a parenting figure to their children. And as they walk through that door, a lot of times they have to give many of those pieces in their bag up. And it may be the right to have the care of their children. It may be the right to, depending on what the issues are, it might be the right to attend a doctor's appointment or choose a care provider. It may be the right about when they see their children or what school they're going to or who they're working with. So they give up each time. They may have to meet with the caseworker or the treatment team and give out another piece. And all of it may be for a better cause of reunification and success, but it's hard for a parent to kind of slowly have to give up pieces that are what make up them as parents, that we all kind of walk into parenting with. And so this is another piece. And so I, as RPC, have to look at that carefully and not, you don't want them to give that away easily if it's not appropriate. And certainly there are situations where, especially if the child is out of home, if there's allegations of abuse, maybe charges, there are circumstances where the parent holding and retaining that privilege, at least at a certain stage of the case, is not a likely reality. And trying to put that, working with the parent and the providers to do what we have to do, but not every case, certainly, is the parent going to be successful on that, and not every case maybe needs to be litigated to that degree. But I think that's the first analysis, is should the parent be the privilege holder? And if they are not going to be the privilege holder, and it is, and then you have to weigh versus, you know, an extreme case where they certainly are not very likely to get that, to other cases where, especially if the children remain in the home, I think it's empowering the parents to have as many of those pieces of their parenting role that they can have. And from my perspective, I would always argue that the parent should retain that right to be the privilege holder and make those kinds of decisions for their children if the children are remaining in their home. If the team and the court has deemed them fit enough to have their children and care for them, then they should be deemed fit enough to do those kinds of things as well. And while they may not do it as well as the GAL might handle it, or maybe everyone's a little concerned about their judgment, it's still part of that parenting piece that we're giving them, empowering them to be a parent, to have their kids and to take on that role. So if they are not given the role as the holder, as was just stated here, I agree that it needs to be reviewed regularly, certainly from the RPC perspective, as the treatment plan moves forward, and hopefully there is success and whatever issues may be between the child and the parent, as those are improving, then there's less and less cause for the parent not to have that role back. And so I think that I certainly would have assumed that we could continue to review that and look at that. Now, in the circumstances where the GAL, or I guess maybe potentially another third party, is the privilege holder, the things that I would look at are, of course, whether or not, if there is a limited, or if there's a release at all, is any party getting information? Is the department getting information, and the parents aren't? I haven't litigated that issue, but I see it as certainly an issue that I would want to take to task, is if it's going to be released to anybody, the parent should have that information as well. The other piece is what is the therapeutic information being used for? Is the GAL just, you know, checking in, making sure the treatment is appropriate for the child? The child is in treatment with the therapist, kind of helping them process what's going on, their visits, whatever trauma, and working with them on it. That's one role where that really never necessarily comes to light for anyone outside of the therapy. That's kind of safe place that we talked about. And certainly with older children, I would agree that's where it stays. However, there are instances that I've encountered before, Lan, and since, where the therapist may have a recommendation that the GAL may want to rely on regarding visits or other matters related to the treatment plan or to the parenting. And so certainly I think that's where we're talking about, is that a limited release? Because if it's a recommendation that the parent, you know, the visitation should be cut back, or there should be supervision, or they should be less, or anything like that, I think that opens, from my perspective, that opens the whole. It's not just opening the door a little, it's opening, and it all should get in, because everything is then relevant in determining how the therapist came to that opinion. And so I would, as RPC, certainly want all of the information if that was going to be used. So I was talking earlier, I was saying that I kind of liken it to, is the therapist along with the child maybe for the ride to help them work through stuff, or is the therapist starting to take on a more directive role? If they're driving the boat, then I really am going to want to know what the information is that they're using to do that. If they are helping the child through this difficult time, then that really is not necessarily something that's going to impact the success of the parents in the treatment plan either way, but hopefully help everyone to get into a better place and a healthier place. And there's always the factor that the mandatory reporting. So if there is a real concern, that of course is addressed. And I think with the issue of whether or not there needs to be a different kind of treatment, I also think that kind of plays out with how the relationship's doing, how the child's doing, that we may see outside of the therapy. Now, if and when the parent does become the holder, and certainly, as I said, I'd be wanting to review that regularly and at the earliest stage possible, if not at the beginning, and keeping that privilege for the parent. I think that what tends to happen is if the parent's holding it, it's kind of access to everybody because they sign releases and then everybody knows what's going on, and that's not necessarily in the best interest of the child. As we as guardian ad litems know, it may not be appropriate that everybody have the information. So I think the parent has the same obligation really to look at the best interest of their own child to decide whether or not releases are appropriate. And I think that's where it gets sticky with treatment plans, and I think generally probably the course has been that having the parent have the holder means more people have access to information because the department asks for releases, and we've even had situations of compromise where that's kind of the compromising part is the parent holds the privilege but allows release of information so the parties know what's going on. And I think that, the other, only other issue we had talked about earlier today was if parents are divorced.
Right.
And
good. Yeah, why don't you address that?
yeah, so they each, that does make it more complicated. Certainly as RPC, you're only representing one parent, or if they're separated. But if they both are seeking the privilege, sometimes, it can be just as challenging as it is in divorce and custody cases where they're at odds about what they're looking for and what their agenda might be. And I think it's kind of incumbent upon all parties to be looking at the motivation maybe behind asking for the privilege, which of course is a requirement before they are holding the privilege anyway. That was all I had.
Good, thank you. Okay, so we got some time for questions. Wait for the microphone. Thank you.
All right. Is this working?
I think so.
Okay. I've seen two dilemmas that I'd like you to address. Under the Chief Justice Directive, as guardians ad litem, we've got a duty to investigate the recommendations of the best interests of the children that are appointed to represent their best interests. If we don't hold the privilege, how do we do a proper investigation? If we can't get necessary information or important information from the therapist because they won't disclose it, if there's no release. And if we do hold the privilege, how do we make our recommendations without impliedly violating the privilege or release of information in telling the court why we're making certain recommendations?
So, sorry.
Repeat the question.
Okay, you're Leo, right?
Yes.
Okay, so his first question was, if we are not the holder of the privilege, how can a GAL carry out his duty to perform a proper investigation, right?
Yes.
Okay, and then the second part of the question was, if we are the holder of the privilege and we are speaking with caseworkers, reporting to the courts, maybe filing court reports, talking to other counsel, etc., could that be argued to be a waiver somehow by doing that?
Right.
Okay. Okay, so I repeated the questions now, panel members.
You don't want to take a stab at it?
You answer it.
You take a stab. I'll take a stab at the first one.
Thank you.
Okay. I kind of like it. When you asked the question, I was thinking back when I used to be a prosecutor, and defense attorneys used to file motions like crazy trying to get the victims of sexual assaults therapeutic records because they needed it for their defense. And so I kind of liken it that way. If you're not the privilege holder as the GAL, then and the information is privileged, and we are taking it very seriously that there are very good reasons why there should be a privacy right for the child in their therapy, then I think that we can't get the information. Do you know what I'm saying? It's like we have to say, wow, we're used to getting that information. We always tried to get that information, but maybe we can't get that information. And if it's privileged, we can't get it unless we can have a release and somebody will sign it who's the holder, or we are the holder. Okay? So if we can't get it, then we don't have, to me, and Linda, you correct me if I'm wrong, any further duty to go any further with that, because privileged information is privilege and you can't get to it. So I think you try to get a release if you think it's really important, but if the privilege holder says no, I think you're done.
And I also think, in response to that, I mean, when you're trying to do your investigation in terms of what's going on with this kid and how am I going to fashion recommendations that meet his best interest, there are so many sources of information for that outside of the therapist, right? So you're talking to the caregiver, you're talking with the teachers, you're talking to these other important people involved in that child's life, and talking to the child, right? Is this going well for you? Are you working through? Do you feel like you're making progress? Is this a good fit for you? All of those kinds of things. I mean, I think that is your independent investigation. And I have to agree with Laura. If it's privileged, it's privileged, and we don't have access to it.
I'm actually going to take advantage of the fact I have a microphone and ask you a question. Ms. Laura, you're so thoughtful about your strategy. And one thing I didn't hear anyone on the panel talk about is the youth engagement piece in terms of your decisions about when to waive the privilege when you're the holder. So the Chief Justice Director requires you to consult with the child in a developmentally appropriate manner in determining what's in the kid's best interest. And especially in light of what Tori said, what is your strategy around that or your approach to doing so? Because this is also a complicated issue to talk to kids about.
Did everybody hear the question? No?
You repeat it.
Well,
Okay, I'll try to talk about it. The question is, what about the youth engagement piece and consulting with the child in a developmentally appropriate manner in your decision about whether to waive?
All right, the question is, GAL's responsibility to consult with the child in an age-appropriate manner to determine the waiver of the privilege.
Any strategies there?
Well, I think it's important, and of course you have to do it, and I do it, okay? Most of the situations I've been in so far where I've been thinking about waiving the privilege over contested are pretty young children. So I really haven't had to delve into it real far with that. But I definitely do think that you need to talk to the child when you're considering waiving the privilege and giving information to other people. And certainly older children, you have to sit and talk to them about it. This is what's going on. That's what I said. This is what's going on. I'm thinking I need this information from your therapist. But because I really am concerned about, wanting to keep that information private and confidential, and I want to hear what your thoughts are. I think it's important to get those thoughts before you make a final decision.
And Laura, the same applies to me. I've only had it come up with very young children so far where I did waive the privilege. What if the child says, well, it's okay for you to tell mom about A, B, and C, but I really don't want mom to hear about, these other 5 items. That could really be a problem. Can you disclose some, but not all?
Like I said, I think you always have to operate from the assumption that limited waivers are probably going to be very difficult to sustain and uphold. So I think once you make a decision to waive, you've got to be prepared that you're waiving everything. You at least got to be prepared for that.
Yeah.
You got to tell the children.
We'd have to tell the kids, look, we'll give it a shot, but we might have to tell them everything.
Right.
And the second half,
the
second
second
question is
question.
answered in paragraph 31 of the court's opinion. The court said that GAL could have conveyed Newland's opinions to the juvenile court in a number of ways apart from distributing Newland's entire letter. So I think if the GAL had the information and disclosed it in a way that did not implicate the statements made by the therapist, that's not a waiver.
I wait.
Oh, okay. She wins. She wins.
I had just a follow-up. If the child is a privilege holder, do you then get him a lawyer, or do you advise him yourself as a GAL?
I think the OCR has taken the position that we need to request separate counsel to advise. Now, it may be, like in my jurisdiction, maybe I could be that counsel for kids in Montrose County, where I don't do much work. And maybe GALs in Montrose County could perform that task for kids in Delta County. That would be a possibility. Phil has the microphone. Okay, speak loud, speak loud, speak loud, Phil.
And not just to repeat, but also maybe to answer. This would be a question about something that the Supreme Court did not settle, and that is to what other professionals, people under, is it 139107, other people under 139107 who have privileges, how does this affect those people? And the two examples I'd have would be psychiatrists and defense counsel.
Okay, so a psychiatrist is a medical doctor, and so the other subsection of the statute would apply. And what was the other example?
Defense counsel.
Well, that raises questions of attorney-client privilege, right?
Which doesn't apply to GAL.
Which doesn't apply to the JAL.
Why not?
Case law.
Yeah, there's case law that says that. Yeah, I'll recite it to you after the seminar. I think that is right. Okay, well, it's 2:31, so. Okay, last one.
Oh, no.
Oh, no.
You get one.
question,
Pick your
Kevin.
best one.
Here you go. Okay, so talk loud.
Well, I kind of have difficulty.
Didn't sound like this.
I kind of have difficulty with the idea of nobody holding the privilege, so therapists can't disclose to anybody. It would seem to me that from the moment the child is born, there's a privilege holder, and it's the parent. The filing of the case, I don't know that changes that. So the question is, who is the default privilege holder until the court enters a decision changing it?
Well, just off the top of my head, I would say parents. I mean,
So
LAN doesn't really say that, but that would be my gut feeling, the parents.
Well, and I can tell you that some jurisdictions, including ours, are going to address that by administrative order. And we're circulating one right now, and we'll talk about it next week with the departments and other parties, but we're going to leave it with parents or guardians or persons with court order decision-making authority, and tell somebody who moves the court to reallocate the privilege.
And I think I've seen an administrative order from Jefferson County, I think, where the default position is the GAL. Right?
Based on what finding of fact?
Pardon?
Based on what finding of fact are you changing?
Well, that was the concern in the 7th. We didn't feel that we had the basis to change it, but we felt we needed to specify it because some of our treatment providers are saying we're not going to provide treatment if you have a privilege holder that's different than the person that can authorize the treatment. So we're not going to...
That's easily taken care of by court order, isn't it?
Not really.
I don't think so, and I don't think we want a court order saying GALs are the people to consent to treatment now.
No,
I don't think we want that.
We don't.
The OCR has been very clear that GALs, it is not our position to consent to treatment. And I think from mental health professionals' point of view, I've talked with a lot of them, they think that's a little weird. You're going to split those two things? You know, from
coming
there.
to that conclusion now?
Not to cut you off, but I'm going to cut you off because the greatest thing about this is that our next session is going to be exactly on that issue.
Thanks,
We have a
Sherry.
15-minute break. The rest of the afternoon is dedicated to the legislature.
Thank you.
Thanks.
Thank you.